Good evening, good afternoon, and good morning as well to all the participants and viewers for this match. My name is Aurélien Laurent. With my colleague will be hosting this match live from the Netherlands, organized by the COAX Foundation. This is the Hague Inter-University Law Debate Tournament between two teams, two universities who have already participated to the day one of this competition 2 weeks ago. So now it is day two match, and I will give the floor to my colleague to introduce the teams and students.
Thank you very much. My name is Ana Maria Urbanova. I am a co-founder of COAX Foundation and coordinator of this competition. It's a pleasure to welcome the two teams back again in day two. We are welcoming Dom Helder Law School from Brazil and the University of West Indies. Today's debate statement was released 7 days ago to the teams. They received it at the same time. They do not yet know which part of the argument they will be representing. The debate statement of the session is: International Court or a tribunal for addressing cybercrime should be created to address the increasing global threat of cybercrime and provide a fair and impartial forum for the resolution of transnational cybercrime cases. So the two teams had the same amount of time to prepare for today's session, and that is about all from me. And I would like to call Ms. Maria Eduarda Milagres Fonseca to introduce herself.
There's a microphone.
Unfortunately, we cannot hear you. Not yet. Unfortunately, that's not the case still. Yes, we have a bit of time. So on that said, Mr. Williams from University of West Indies, the floor is yours.
Hello, good day. My name is Marvin Williams. I'm a year 3 student at the University of the West Indies, St. Augustine, and I am indeed excited and look forward to this debate today.
Thank you very much. From Dumbledore Law School, Ms. Sofia Campolina.
Am I audible?
Yes, you are.
Okay, good day for you all. My name is Sofia Campolina, and I'm from the third year of law school in Dom Helder Câmara in Brazil.
Thank you very much. From University of West Indies, Ms. Sana Sokdo.
Good day all, my name is Suwana Sukdeo. I'm currently a year 3 student at the University of the West Indies St. Augustine campus, and I look forward to today's debate.
Thank you very much. Ms. Leana Luchman, also from the University of the West Indies.
Hi, good day everyone. Good morning, good afternoon to all. My name is Leanna Lachman. I'm a year 3 student here at the University of the West Indies with the Faculty of Law, and I'm happy to be debating today, and I look forward to both of our teams making a great debate.
Thank you very much, and again, welcome to the session. Ms. Fonseca, did you have an opportunity to try and connect to your microphone?
I think that should try to change devices. If you all could just wait a second, I'll be very grateful. Thank you.
That's completely all right. For the side of those not in this live session, we always have a little bit of time window to allow for any technical difficulties to be resolved. Right. Perhaps allow me a bit of informal question then to the two teams. We usually do it towards the end of the session, but we can also break the ice now. From the team from University of West Indies, did you have a chance to visit Brazil, perhaps?
I can't say that we have, but if given the opportunity, we would love to. Perhaps we can hear from our teammates, well, our opposing side, what we'll be able to look forward to if we get the chance to visit.
Well, Brazil is a very welcoming country. So in case you all have the opportunity to come here and even come to Belo Horizonte, there is the city where Dom Helder is, we will be very eager to receive you all.
Right, so perhaps there's an opportunity for the two teams to also meet directly. Ms. Fonseca, did you have a chance to visit Trinidad, perhaps?
I haven't. I would be delighted to have the opportunity, and if the time comes, perhaps even encounter our adversaries. Sorry.
Yes, so Miss Fonseca is connecting back.
Hello, can you hear me now?
Yes, loud and clear.
Okay, I'm sorry for this.
It's completely all right. The floor is yours for introduction.
So, good afternoon to everyone. My name is Marituado Milagres Fonseca. I'm from the Elder Law School in Brazil, and I'm right now in my 4th year of law school.
Thank you very much. Welcome. I'll be passing the floor to my colleague who will then shortly share his screen for the randomizer of the positions, and he will know which side of the argument we'll have during the session.
Yes, indeed. So there are two positions possible for this match, as you know, as usual. So in favor and against. So we'll share my screen. So now it is in place. Up. Voilà. So everybody will be able to see the wheel. So normally now you should see in a few seconds the wheel. Yes? Yes. So at this moment, yes, there is a wheel with two possibilities, to be in favor, to be against, for Dom and Law School and for the University of the West Indies. So now I will just click in the center and you will know which position you will have for this match. So the University of the West Indies will have the position against, so it means as a consequence Dom Elder Law School's team will be defending the position in favor and as well will be starting the match having the position in favor. So it means concretely that Dom Elder Law School will defend the position that international court or tribunal for addressing cybercrime should be created to address the increasing global threat of cybercrime and provide a fair and impartial forum for the resolution of transnational cybercrime cases. On the other side, the University of the West Indies will defend the position that international court or a tribunal for addressing cybercrime should not be created to address the increasing global threat of cybercrime and provide a fair and impartial forum for the resolution of transnational cybercrime cases. So now my colleague will share her screen. For the 5 minutes countdown, when you can close your camera and microphone, and as well, yeah.
For the sake of audience, when you will see a yellow card on the screen, the speaker has 30 seconds left. When you see a red card, the speaker's time is finished. They can still conclude their sentences, but likely won't be starting anymore. Best of luck to both teams. Thank you very much. We have now concluded the preparation stage for the two teams. Opening up the session with the opening statement in favor of the debate statement for the match, which is that the International Court or a tribunal for addressing cybercrime should be created to address an increasing global threat of cybercrime and provide a fair and impartial forum for the resolution of transnational cybercrime cases. Starting with the Mulder Law School. The team has now 4 minutes. Whenever you're ready.
Am I visible and audible?
Yes, you are.
Honorable judges, counterparts, and others present, greetings. My name is Maria Eduarda Milagres, and alongside my fellow colleague, Sofia Campolina, and we defend the thesis that there should be an international court or tribunal for addressing cybercrimes. Your Excellencies, with the current development of technology, cybercriminality is constantly growing and is becoming a huge threat to people's rights and can even represent a threat to democracy, as there is a massive share of fake news and social media. So, I would like to establish here all three main points. First, we defend the creation of a specific court for addressing cybercrimes. Second, the sectorization of organizations is a tendency in international law, and it allows the work to be optimized and the discussions to be deeper. And third, cybercrimes are more complex than the conventional ones, and they require specific measures. The phenomenon of functionalization is a tendency in international law, since there is a process of sectorization of legal branches becoming more competent in the matter, as has been done with several international organizations, such as the WHO, the ILO, the Mercosur, and UN agencies. It's also important to remember that cybercrimes are extremely complex. Since they have their specificities, they require a deeper analysis, they have a different structure, and they face difficulties in determining competence. After all, they are transnational and they can affect people anywhere in the world. Therefore, we need a court that escapes from classicism and can adapt to this type of crime. To exemplify, the Rome Statute affirms in its Article 12.2a that there will be jurisdiction when the conduct takes place in the territory of a state party. In the investigation of the case, Bangladesh Myanmar, the ICC accepted its jurisdiction when only part of an offense took place in the territory of a state body. However, this could be seen as an abuse of conventional terms, affecting the sovereignty of states that do not consent to this type of crime, and also the states that were not signatory to the treaty. So, the usurpation of sovereignty, seen in this case, could bring an express infringement of the conventional norms. So, to prevent tragedies from happening in the cyberspace, such as the leakage of personal data, terrorist acts, genocide, and the share of fake news related to serious issues such as the vaccines during pandemic or even about the elections, we have to take cybercriminality very seriously. And the best way to deal with these crimes is with the creation of a specific court for addressing them. Because this way they can deepen this theme and be dedicated to only combat the crimes on the internet. Thank you.
Thank you very much for your submission. The team from the University of West Indies, you have 4 minutes for your opening statement against the statement, against the presented debate statement.
Esteemed judges, organizers, and fellow debaters, as a student of the University of the West Indies, St. Augustine, it is indeed an honor to be debating here today. In the information age, data is arguably one of our most valuable resources. With this in mind, the motion under discussion proposes the establishment of an international court or tribunal as a legal response to provide a fair and impartial forum for the resolution of transnational cybercrime cases. In response to this motion, my colleagues and I will present 4 compelling arguments outlining how the establishment of such a court or tribunal would violate some fundamental principles of international law that have been established through years of careful negotiation and consensus building. Our key arguments are as follows. Firstly, the introduction and establishment of said court or tribunal does not guarantee that it will be effective or even successful in achieving its goals. It is unclear how such a body would be able to enforce its decisions, particularly in cases of non-cooperative member states or rogue actors who refuse to comply with its decisions. There is no guarantee that member states will A. submit to the jurisdiction of the court, B. consent to extradition requests, or 3. support the enforcement of judgments delivered by the court. Second, the existing legal framework to combat cybercrime is effective and is the best legal response to provide a fair and impartial forum. We support the need for international cooperation in combating cybercrime, as stated in the Budapest Convention, but we do not believe that an international tribunal or court is required to achieve this goal. Third, the establishing and maintaining of such a court or tribunal would necessitate significant resources and funding. Furthermore, we submit that some funds would be better put to use supporting national efforts in combating cybercrime. This is clearly demonstrated in the work of the United Nations Office on Drugs and Crime, which emphasizes the need for national funding to build capacity within states to combat cybercrime. Finally, the establishment of said court could lead to a dangerous concentration of power with the potential for abuse and politicization of legal proceedings. For example, while the ICC was intended to be a fair and impartial body, it has on several occasions faced criticism for its perceived bias and politicization from several states. Thus, an international court or tribunal to combat transnational cybercrime could be vulnerable to politicization, with powerful nations using their influence to shape legal proceedings in their favor. As I conclude, it is undeniable that the establishment of said court or tribunal would pose significant challenges to the existing international legal framework. Moreover, it risks creating conflicts and contradictions which would undermine the very principles of justice and the fairness it aims to uphold. We must instead focus on supporting national efforts to combat cybercrime and strengthen international cooperation within the framework of existing legal laws and treaties. I thank you.
Thank you for your submission. Returning the floor to Dumb Elder Law School for your first rebuttal. You have 2 minutes.
Am I visible and audible?
Yes, you are.
Honorable judges, we thank our counterparts for their presentation, but I must express our disagreement. Initially, we must state that although the international courts and tribunals have broad competence, it is visible that they are not prepared to address the topic with the expertise needed. If we stay away from change to avoid bureaucratic barriers, how else will we improve? In order to deplete conflicts of a specific legal reality that demands technical expertise, based on the singularity of the matter, it is required the creation of courts with eminently specialized character. It is clear that cyberspace has brought up new concerns, as now we face issues such as the consumer harassment of hyper-vulnerable people by telematics. And although the consumeristic principle of favor debelis already assures protection towards the hyper-sufficient, the question remains: how can we assure this protection in cyberspace? As we face a digital era with controversies such as fake news and how they influence elections, the search begins to find more severe ways to find this information. For this instance, the pandemic showcased how catastrophic misinformation and unreliable sources can be, since they were the reason for the loss of several lives. So, in order to address the global threat of cybercrime, we see no better way than to create a permanent international court, not only to give the matter its importance, but to assure that those transnational criminal acts be resolved by the most competent authority. Thank you.
Thank you for your submission. Debate team from the University of West Indies, you have 2 minutes for your first rebuttal.
Although I do acknowledge my learned friend's point of view, they fail to recognize that the creation of an international court or tribunal would require significant resources and funding, which could be better utilized in supporting national efforts as countries all over the world suffer from a deficit at a national capacity to deal with cybercrime as highlighted by United Nations Office. It is thereby inaccurate to argue that the sectoralization of international law by a specialized tribunal means that this will address the threat of cybercrime. Our argument is supported by the fact that nations have already established domestic laws and law enforcement agencies to combat cybercrime within their own borders. The work of the United Nations Office on Drugs and Crime highlights the need for funding at a national level to build capacity within the states to deal with cybercrimes. Therefore, the establishment of an international court or tribunal could potentially divert resources and funding away from national efforts to combat cybercrime in violation of these international covenants. Therefore, rather than creating a new international legal body, it would be more effective to focus on strengthening existing domestic laws and law enforcement agencies within the said individual nations. It is of utmost importance to financially improve the technical resources on a smaller scale judicial system and sustain state authority on cases relevant to their jurisdiction, thereby bolstering the expertise and resources at a national level would allow for easier access to a judicial system to prosecute said offenders. Thus, dismissing such an imperative economic basis could potentially lead to an institutional downfall. Thank you.
Thank you for your submission. Dunhilder Law School, have 2 minutes for your second rebuttal.
Am I visible and audible?
Yes, you are.
Your Excellencies, whilst the debate on the possible creation of a special court for environmental litigation hatches, may we focus on what makes it the ideal way to provide a fair and impartial forum for the resolution of transnational cybercrime cases. In transborder scale, it is still unsure how to define the territorial competence of cybercrimes. There is a never-ending debate whether it should be considered the place where the provider is, the place of the committed act, or the place where the victim suffered its damages. Therefore, the creation of a court to address specifically cybercrimes could be the means to solve this issue of contest. Moreover, even though the creation of specialized international tribunals are subject to controversy in international deliberations, it cannot be denied that globalization demanded technically specialized cooperation networks with a global scope. According to Koskoniemi report to CDI, general norms cannot resolve every conflict. Hence the need to take account specialized objectives of each context. Therefore, through the intergovernmental cooperation, the creation of an international permanent court to address cybercrime would not only treat the topic with its technical peculiarities, but also have the fluidity to address dilemmas such as telematic incited genocide in a way that the already existing courts cannot as we've seen from the International Criminal Court. Thank you.
Microphone.
Oh, apologies. Thank you very much for your submission. University of the West Indies, you have 2 minutes for your rebuttal. Whenever you're ready.
Hi, good afternoon. I believe I'm having some audio problems. Would you mind repeating that?
Yes, you have 2 minutes for your second rebuttal. Whenever you are ready.
Am I being heard?
Yes, we can hear you. We cannot see you just yet. Yes, now we can also see you. Thank you.
I unmute then.
When you're ready, please turn your camera and microphone on, and you can start your second rebuttal.
Hi, we're facing some technical difficulties with our other device. Are we being heard on this one?
That's all right.
Thank you. So I must, may I begin?
Yes.
Thank you. So I must thank my friends on the side of Dom Helder for their argument. However, I must point out that having an international court for the protection of cybercrime, whilst it is a great idea, it lacks clarity and formatting. We argue that our friends on the other side fail to recognize the creation of an international court, which would require significant resources and funding. This could be better utilized in other areas of law. Additionally, our friends named the Bangladesh case and other cases which are very important. However, it lacks severe formatting in terms of having proper and structured arguments for having a cyber court. We, however, must look to cases where an international court may have failed. For example, in the case held in The Hague between China and the Philippines for the South Sea case, China was held accountable for their actions. However, instead of going forward with what was purported by the law, there were no mechanisms in place for China to actually have the cases held in place. Thus, what we are fighting for on the negative side is not for there to be no court, but for a court where there can be a proper structure, a structure which will ensure that cybercrimes are properly enforced. Our friends on the other side mentioned the lack of democracy. Lack of democracy comes in place when we have cybercrime cases such as the DNC case, whereby actors in Russia were able to affect the democratic process in the United States. The United States electoral election was affected, and we cannot have that. Thank you very much.
Thank you very much. We are now proceeding to the conclusion. The Melder Law School in favor. You have 2 minutes for your conclusion.
Am I visible and audible?
Yes, you are.
In conclusion, honorable judges, to reassure that there should be a permanent international court or tribunal for addressing cybercrimes, we may look back on what we established. It's evident that no one should be judged if not by the most competent authority. And by that, we aren't saying that the existing tribunals aren't competent, but we want to reinforce that the creation of a permanent international court for addressing cybercrimes would not only provide a fair and impartial judgment for these crimes, but also would escape from classicism and adapt to the complexity that this type of crime requires. Also, it must be reminded that functionalization improves the quality of work and makes discussions deeper. So, the sectorization is inevitably a tendency in international law. That's why we believe that the institution of a permanent international court for addressing cybercrimes would be the most effective measure to deal with this current issue. After all, the most important is to overcome the infodemic of misinformation, as said by Antonio Guterres, the chief of the United Nations. Thank you.
Thank you very much for your submission. University of West Indies in against position. You have 2 minutes for your conclusion.
Given the arguments raised in opposition to this motion, do you believe that establishing an international court or tribunal to address cybercrime would be the most efficient solution? Or do you agree that another, more efficient approach could be pursued? In our arguments, we outlined that the sectoralization of international law is not the answer. The establishment of an international court or tribunal does not guarantee its effectiveness or success in resolving transnational cybercrimes. Also, the best existing legal framework to combat cybercrimes is operating effectively and is the best legal response to provide a fair and impartial forum for the resolution of transnational cybercrime. Consequently, it is imperative that we turn our attention and make sure it is directed towards bolstering national endeavors aimed at combating cybercrime while enhancing global collaboration within the ambit of prevailing international law and treaties. Therefore, it is reasonable to infer that the implementation of an international court or tribunal as a countermeasure to the increasing threat of cybercrimes is not the best legal response. History has shown us that obtaining universal acceptance for an international court is not an easy endeavor. Additionally, it is important to consider the likelihood of such a court being exploited for political gain, which would compromise its role as a fair and impartial body. Instead, we must seek to prioritize efforts in collaboration on a national level. Above all, we must protect measures and safeguard the principles of international law. Thank you.
Thank you very much, and thank you to both teams for your submissions and for your preparations. We have now concluded the part of the session which is graded by the judges. Feel free to relax. We'll do a little feedback session and then conclude the match for today. That said, I would like to invite Ms. Suna Suktu to give your opinion on the match. How did you find the preparation? How did you find the match itself? Once more, calling for the University of the West Indies, Ms. Suna Suktu. If you would like to give your feedback on the preparation and for the match.
It was a pleasure to participate in this debate today. I thank the Hague and the Corax Foundation for facilitating us. My colleagues and I share the same sentiments. We are really grateful to be given this opportunity to debate against Dunhelder Law School. They put forward great arguments, which in our case, we have also combated them with great arguments as well. So I do thank everyone for participating today.
And I look forward to seeing you guys into the future.
Thank you very much. As we are now in the feedback session, it's also possible for participants to open their cameras. And that said, calling for Ms. Sofia Campolina from the Helder Law School. How did you find the preparation, the match?
Well, not only me, but my team and my coach helped a lot during the process of the preparation of the whole speech, how to select arguments. It has been really great to participate in this competition, and I look forward to the next round. Thank you.
Thank you very much. Returning back to University of the West Indies, Mr. Williams, perhaps a bit of twist on the previous question. Did you already encounter similar topics in your studies?
No, this is actually a new area of study. It was actually a new area of study for us. It was quite interesting to learn some of the things we did. It's the law is incredible, and we just look forward to more opportunities like this where we could expand and grow in knowledge. Yeah. Thank you again on behalf of my team and I.
Thank you very much. Ms. Maria Eduarda Milagros Fonseca, how did you find the debate? Did you already encounter this in your studies?
So firstly, I would like to thank my counterparts for the debate and all the organization. It was very, very good to be part of this. It's been very interesting and productive. So I am really grateful, and I am very excited for the next round. It's been excellent to be part of this competition. So thank you a lot.
Thank you very much. Ms. Liana Luchman, how did you find the debate and perhaps the topic in regards to your studies as well?
Yeah, so I found the debate today was excellently done. I must bring up how well both of our teams did. I think it's interesting in debating how we bring up topics that the other team can come back and rebut each other and have a lovely discussion whilst promoting similar goals. And in terms of cybersecurity, it's something that we haven't come across in particular in our studies. We studied general public international law and even Commonwealth Caribbean human rights law. And all of these elements come together. So it was interesting to see how they interacted with one another. And again, wonderful job to our friends over in Brazil.
Thank you very much. And once more, good job to both teams. And thank you for your submissions during the session. I'll be passing the floor to my colleague who will be concluding the debate today.
Yes, so many thanks for this debate to both teams. Very good work and very good debate on this topic of the courts for cybercrime. So what I would like to tell is obviously that was the second day of the group phase. So it means you already had a match against two other teams from this group. The next match will be against the last team from your group that you did not have a match with yet. So it means for you, the University of Manitoba, that will be for Don Helder Law School, and Tilburg University, that will be for the University of the West Indies. So you are in the Group D. So in 2 weeks you will have this match. So it means during the next days, first you will receive, of course, the assessment and the score for this match. So the judges are watching, or they will be watching during the next hours this match. And next week you will receive as well the topic for the last match of the group phase. So it means, around next week is the moment when you will know. It will be on a different theme, not the same theme from this second day of the group phase. So another theme, still connected to the sustainable goals of the United Nations. And so yes, so that is what is coming. So I think indeed we covered the question on if you already visited each other countries. But of course, what would be great is that you keep contact in the future. You never know what life brings to you. If in Brazil you have to go to the Caribbean, then you know where to have the first contact with, for example. And same on the side of Caribbean students, when you come to Brazil, even if Belo Horizonte is very, very far, because Brazil is very, very big. But still, I mean, that would be a good way to connect. And of course, because you are in a part of the world where you have as well a lot of exchange between the countries around, because between, I think, Brazil and Trinidad, there is only Venezuela, so only one country which is making the difference between the two countries. So yes, in any case, many thanks for your contribution, for this very good debate. We'll keep in touch, and of course we'll see each other around 2 weeks from now for the third match. Okay? Many thanks to my colleague as well who have been hosting the match, and we keep in touch, of course, and you will see as well as some announcements about the different match. We advise you as well, of course, to watch other match, not just from the teams that you will have a match with, but just to see what is happening in the rest of the competition as well. Okay? Voilà, so many thanks to everybody. Many thanks as well to the coach, I guess, who will be watching or who are watching the match possibly on YouTube. And yes, we'll see each other in 2 weeks. Bye-bye.
Thank you, everyone. Well done. Goodbye.
Bye-bye.